Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello. Is this thing on? I think it is now. I hope everybody's doing well today. Happy Saturday. That's right. It's the weekend. Play whatever weekend song that you play in your mind. Love to hear it. And we have some court to get to. I have some things to get to later, so we have to get a move on, if you will. That was said to me so much when I was little. Get a move on, Paisley. Get a move on. Get a move on. Getting a move on. Getting a move on.
There we go, Ms. Rodriguez,
Got our move on.
Mr. Espinosa. Okay, this is case 37973, and just bear with me while I get your file open.
We'll bear with you, Judge. Oh, loud.
Seven,
Picked the wrong day. Cindy, thank you. It went really well. We'll see. I'll know more next week. Details, so official details.
Pierce. There it is. Okay. All right. So Mr. Espinosa and Mr. Rodriguez have your claim here against Mr. Fulton. And what I am looking for, and I do not see, is proof of service of the claim on Mr. Fulton. So without that, your option at this point would be one, you can reset your case to a new trial date and then use that time to serve notice on Mr. Fulton, or you can dismiss your claim without prejudice and file it at another time, but it's entirely up to you.
I was gonna ask Your Honor, my landlord Gina, she got a private investigator to try to serve him, and we haven't been able to serve him. So
Yeah.
I don't know if we could do it through notification of social media.
If you can prove service by social media, you can do that. I'm not telling you, how you can do service.
By social, I've never heard of this. I've heard of publication by notification by publication in the traditional print media, but notification by social media post? What? How on earth? No way. Oh my God. I'm aghast. This is my limit. Apparently we've hit my limit in terms of, I mean, it's just, I don't know, like publicly, no, but through print media, the whole point is that you don't, but it's incumbent upon people, like, I don't know, I just find it interesting. There's a lot of repercussions with that. My whole point is like, for example, this happened to me recently. I'm not on Facebook. I haven't been on Facebook in like 5+ years. But I have a Facebook because I have a lot of photo albums on there and I just don't give a fuck. So it's just there. I don't sign into it. I don't get notifications about it. I don't use it. I've decided not to use that kind of social media. For me. Most people don't believe me when I tell them this, and then they legitimately get it, finally. Like, oh, she really doesn't use it. I really don't use it. And somebody recently told my roommate that they tried to add me on Facebook and were offended that I didn't answer, like reply or whatever. And I was just like, I had in no inclination of getting that notification, and it's just not how I would go about like talking to anybody. But anyways, besides the point, I guess Judge won't explain it because he doesn't want to.
Service, as long as you do it in a legally acceptable way, is fine. There are different options.
Okay, because
Yeah.
it said that you had to approve it first before we try to do this.
Oh, yeah, you absolutely have to have proof of service. And I see that from what you filed here, it looks like at least there was one attempt to try and serve him, but it looks like that wasn't successful. So, okay, I can have the clerk give you another trial date, or it's up to you how you'd like to go.
Yes, please.
Okay.
Well, am I able to speak up really quick? I'm
Yeah, but-
Iris's landlord. I don't know if
Uh-huh.
so I thought we had put proof of service. So we had a private investigator that tried to serve him 4 times and was unsuccessful. And then we also tried to serve him via certified mail, and that was unsuccessful also. And I thought in the file we had put both of those proof of services. Is there more that we
Yeah,
need to do?
That shows that he was not served.
Oh, gotcha.
Yeah.
Okay.
Yeah, I understand that he was not served.
Sorry, I see what
Some
you, I
documents.
misunderstood.
Yeah.
I misunderstood. So are
Yeah,
we
you need a
able?
successful.
Yeah,
proof of
gotcha.
service.
So do we have, I guess the question is, do we have permission from the court to serve him via public notification?
No, you can't do that by
Okay.
publication yet.
Okay.
No, that all the other proper, normal avenues of service have not been exhausted yet.
Okay. So
it
what
sounds
would
like
be
you just
the
need
next?
to keep trying.
Okay. So keep trying the avenues that we've been trying.
Yeah, you did. I think you did basically the thing that most people do, which is process server. They're usually
Yeah.
pretty good at doing it. I know they cost money, but they do this for a living, and they're usually pretty good at finding people to deliver legal papers to them.
Okay.
Okay, let's get
And
you a new date here, Chase.
okay.
We are looking at December 27th as the soonest.
All right, let me look at the calendar. Are you, Ms. Rodriguez, Mr. Espinosa, are you okay to do this on December 27th, or do you want another date?
That's fine.
Okay, then December 27th it is, and we'll see you back here then.
Thank you.
All right. And I was checking to see, I don't think I have any other one-party cases. It's like a lot of people are here. All right, and then I would understand that Arlo Kaschanka and Deborah Macy had previously already engaged in mediation and didn't want to do that again. So if Kaschanka and Macy are ready, I can take your case now.
Here.
Okay, and again, just be patient with me. I have to get your file open. This is case 37329. Oh, I've got it open. And I want to make sure I'm pronouncing people's names correctly. It's Arlo Kaschanka.
It's Kashyaka, but yeah, that's close enough. Arlo Kashyaka.
I gotcha. I will do my best to get that right. And Deborah Macy. And I get you started here in a second. I just need to bring up documents from your file. All right, so this is the plaintiff's claim against the defendant for $925.13 based on a security deposit. Okay. All right, the way we'll proceed here today is I'll swear the parties in, and then the plaintiff gets to go first and present your case first. And by that, I mean you can testify yourself. You can refer me to various exhibits and documents that are already in the court file. And you can also have people testify if you have witnesses that you want me to hear from. After I hear from the plaintiff, then it'll be the defendant's turn to do the same thing. Testify yourself, draw my attention to documents and exhibits that are already filed in the court file. And then you can also present any witnesses that you may have. During the time that we're doing this, I'm going to ask you to follow a couple of rules. One is please don't interrupt the other party when they're presenting their claim or their defense. Keep in mind that I'm very likely to hear different versions of things. The other party may say things to me that you don't think are true or correct, but keep in mind that you either will get your chance to tell me your version in a few minutes, or you've already told me your version, so I've already heard it. I expect to hear different facts, so you don't, I'm going to ask you not to interrupt the other party. I may need to ask you questions from time to time, and the reason I would do that is just to make sure that I understand your claim or your defense, and also I would do that to kind of keep things on track, to focus on the facts and circumstances that will help me to actually resolve the case. Some facts that you may want to talk about may not really be relevant to that process, so I might want to redirect you a little bit from time to time. So with that in mind, I'm going to ask you both, raise your right hand, please. And do you both swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, then I am going to hear from Kasianka first. Go right ahead.
Thank you. I'm requesting to have the remainder of my security deposit returned by the defendant. All of the items that were deducted from the security deposit would fall under where from normal use, according to RCW 59.18.260. This includes the charges for the carpet cleaning, filling pinholes, painting, and minor maintenance to old fixtures. And this home was built in 1895, and many of the fixtures in the home were on the older side. So, like light fixtures, like not quite fitting properly and things like that, and drawers not quite on the sliders. And so from that perspective, it's understandable from my perspective that fixtures, those kinds of fixtures need more regular maintenance than something that was new. And additionally, the largest expense that was notated on the security deposit disposition was not itemized, which is required by law. It was a lump sum for multiple items that were listed underneath that amount, but no specific itemized amounts were provided for those on the security deposit disposition. And I would also argue that even with that, those items that were listed under that section were also things that would fall under the legal description for normal use.
Is there not a mechanism in the tenancy branch to handle this? Where I live, there's a tribunal that deals with landlord-tenant matters. Judges in regular court do not hear it unless it becomes more significant. There's appeal processes, but to begin with, it's a tribunal that what do I say? How do I say? Like, I'm not saying it's perfect because it is a very long process, but it is a process nonetheless. And there are like very strict sort of standards. I've gone through it once with my old roommate. We won, but it's still very expensive, as they say, to execute, unfortunately. But anyways.
I attempted to remedy the situation with the errors in the security deposit return with the defendant, and you can see in the file the letter that I sent to the defendant asking for the remainder of the security deposit to be returned with the reason why and the legal links to the legal information that was explaining why. I sent this to her twice via email and did not receive response and willingness to pay the remaining amount. I also want to point out that the defendant, I did hire a process server to serve the defendant, and I texted the defendant letting her know that there was going to be I know I probably shouldn't even have done this, but I texted her to let her know that there would be somebody who would be delivering her legal papers. And that process server showed up for 2 weeks straight trying to serve the defendant. And on 2 attempts, she was home, but did not come to the door. So we could not serve her, and we had to use other methodologies to serve her. And with all this evidence set forth, I believe that I'm at minimum entitled to the amount of funds that I have requested in this case from the defendant under Washington state law, and if not more, for the delay in payment. This totals at least $925.13, which includes the security deposit amount not returned within 30 days of move out, plus the charges that the defendant charged me for stop pay on the first check that she had sent to me with the incorrect legal name presented on the check, so I could not actually cash the check. And then also she charged me for the certified mail charges and the printing costs, so I would like to request for those to be returned as well. And I recognize that I might be entitled to more than just the $925.13, but that is all I'm asking for. And I feel like that's fairly generous considering what I'm entitled to. I do want to just add some clarification around the issue with the name on the check. And I don't think that this is even a necessary part of my argument. However, the check that was originally sent to me within 30 days of move out did not have my legal name presented on the check. And so I could not actually cash that check into my bank account. I was eventually provided a check that had my legal name on it because I asked for it, but I just wanted to note that.
Can I ask you just 1 or 2 quick questions? Can you tell me how long you lived at the house?
I lived there for about 1 year.
1 year? Okay. And can you give me the approximate dates when the tenancy began and when it ended?
It began early September of 2022 and ended early September early September of 2023.
So you're...
Oh my god, did you see the Creed frame moment there? That was so funny. We have to go back and watch this Creed frame. So funny. Oh my god.
Early September early September of 2023.
So we're talking a 1 year period of time that you were there.
Yes.
Okay, understood. All right, and I am going to hear from Ms. Macy, but is there anything that you feel like you need me to know before I make a decision in the case? Because you won't be addressing the court again on this.
I would like to encourage you to take a look at the pictures that were provided of the damages that the defendant was claiming. I don't know how well you can even see them, but though, like, I don't actually see what the damages are, and no pictures were actually provided of the carpet or the pinholes that were claimed to needing to be filled as a part of this security deposit disposition.
Yeah, I do have the pictures up here in the defendant's exhibits. Okay. All right then, thank you. Ms. Macy, you can go ahead and present your side of it.
Thanks. I didn't provide a formal statement. I just thought that we could look at the exhibits and they would prove that this isn't normal wear and tear. Like Arlo said, she was just there for a year, and in a year to have the issues at the end of her tenancy that existed. We had over 60 push pin holes in the walls that we had to fill. We had damage to a brand new front door, and I did provide a receipt for that door to prove that it was brand new when she moved in. The remount of the bathroom ceiling light, the damaged cabinet base. If you look at exhibit, hold on, I'm trying to get to my exhibits. Exhibit C, when Arlo filled in the property checklist when she moved in, she did go into the kitchen and she did I always allow my tenants to walk by themselves through the property for their inspection. I don't want to hover around them because I don't want to make them nervous. Arlo was very fastidious about opening every cupboard, opening every drawer, looking at everything, which is exactly what I want. I want them to note everything. And she did. She did a great job with the property checklist of marking everything that she found, including on Exhibit C, page 17, on the kitchen notes, noting staining under the sink. And I'd like to make sure the court realizes that that sink that she opened, admits to opening the drawers, cupboard drawers to view, is about 3 steps away from, if she just turned around, she would be at the drawer that was busted when she left the residency. And I did stand in that area and I did watch her go through that kitchen, and she opened every drawer, she opened every cupboard. Anything that she found would have been noted on this sheet, and there's no reason for a broken drawer to be left behind for me to deal with. As far as the light that had to be repaired upstairs, that was a brand new light. I had just hired a contractor to build that closet that the light resided in. That closet did not used to exist in that room. That was built for. We had done a complete remodel before Arlo moved in, a $16,000 remodel. That closet was built at that time, and that light was brand new. And you can actually see, if you look at the pictures that are included on Exhibit C, page 21, you can clearly see that the kitchen drawer is broken in that. You can clearly see the closet door broken from the track. And this wasn't just a matter of it being moved out of the track. That's something I could have fixed. The hardware was totally gone from this. And I also included the receipt for that. All my closet doors were brand new in the house when Arlo moved in. That same page, you can see the kitchen cabinet wall pushed in. That flooring was brand new, and I also included a receipt showing that the flooring was brand new, installed by a contractor. The contractor did not leave a gap there. It was clear that something had been pushed against it, like slid against the floor, because this is at the base of the cabinet where the sink resides. And it was clear that something had been slid across the floor and hit that with such force that it pushed that in. And I had to have the contractor replace that. You'll see mention on that same page of the GFI in the bathroom being tampered with. You can tell it's tampered with. You can see that somebody has been in there with a screwdriver removing it, and they did not get it placed back correctly. When I walked into that house for my inspection after Arlo moved out, that bathroom light that you see broken from its base was flickering, and the closet ceiling light was hanging by its wires. Both of those were hooked up to this GFI thing. So we could tell, contractor could tell that the bathroom had been tampered with, the GFI had been tampered with, And we ended up changing out that bathroom light. I did not charge her for that. The light fixture hanging from the closet ceiling, you can tell that that's a brand new fixture by the blue plastic that it is housed in. That is not an 1895 base. And again, this was all work done by the contractor. The work that was done before she moved in was all done by my contractor. You can see on the next page of Exhibit C, you can see the damage to the metal front door. That was a brand new door. You can see my receipt there for it. It looked like she had tried to nail something into my metal door. And then you can also see some scratches about 6 inches underneath that nail hole where something had been hung there and you could see that like the wind or something had shifted it and it had scratched the door. So we had to fill that and repaint. Again, I've lived in my house for 30 years and none of these things have ever happened in my house. These are not normal wear and tear. I expect when a tenant leaves, I expect it to be left broom clean. Arlo certainly did that. It was broom clean. But that doesn't change the fact that these problems are not normal wear and tear, and it should not have been left in this way. I'd also like to direct your attention to Exhibit T, page 59. The lease. I belong to a Rental Housing Association of Washington, and I belong to them for a reason. I want all of my leases, all of my forms to be as current as possible and up to date with the RCWs. And it clearly states that if there is a maintenance issue, it needs to be reported. And it also clearly states that the house needs brought back to the condition it was in before the tenant took occupancy. You can see on here on page 59, there are several pages here of emails from back and forth between Arlo and I talking about the only maintenance issue that she ever reported while she was in there. And you can see if you read that text that I did my best to mitigate what was happening as quickly as possible, including going out and buying something an evening before I was scheduled to leave town and delivering it to her back door so that she would have it before I left town. And then you can see that I checked in with her afterwards to make sure it was okay. If these items, as Arlo had stated when we mediated the first time, Arlo had stated that all of these problems existed before she moved in. And if that were true, they should have been reported at the same time that this issue was reported, because we were certainly taking care of things at this time, and that would have been a great time to take care of it. I'd also like to respond to what Arlo said about the server and me being home twice when she was here. I wasn't actually, I mean, that's kind of true. The first time the server came to my door, she posed as a DoorDash person delivering food, which I hadn't ordered, so I had no reason to answer the door. And I did talk to him.
The service of process isn't really important to me deciding this case.
Okay, great. I just thought that I needed to counter what she had said. You can see before photos. They are presented. Hold on, let me see. I've got my table of contents here. I do have before photos that are, let's see, it's Exhibit G, shows before photos of all those areas. The only thing, Arlo mentioned the pinholes. The only thing I didn't get a picture of is the pinholes, and that's just because I can't get pictures of the pinholes. They're too small. They wouldn't come out. Everything else I have pictures of. You can see on Exhibit G, page 30, the photo of bedroom 1 with the new closet doors that I've already shown a receipt for. You can see the bathroom that had the GFI that was tampered with and the light tampered with. You can see the bedroom closet. Like I said, that was a brand new bedroom closet. We had just created it. There used to not be a walk-in closet in this bedroom. That used to be hall space. I took away from the hall. changed where the entry door was. In fact, you can see where the original entry door was because you can see that I've added a light switch to the bedroom. You can see one on the wall and you can see one out in the hall wall. That's because I altered the entrance to this bedroom to accommodate taking up the hall with that closet. You can see in photo 4, the kitchen drawer looking just fine. And again, inspected by the tenant before she moved in. Unfortunately, Exhibit G with the kitchen cabinet doesn't show very well because it's dark under that cabinet, but you can see that's new flooring. I just put that flooring in. My contractor that installed it would not make a mistake of having a gap between the cabinet base and the thing. And you can see photo 6, the front door, the metal damage hanging. I don't know how important it is. I didn't realize I could have witnesses here, or I would have had my daughter come here today because my daughter has been with me on every project. She's my right-hand man, my huge assistant. She knows what this place looked like before Arlo took over, and she knows what it looked like after Arlo left. My daughter has been with me every step of the way, and she did include a statement. If you look at, hold on, I'm trying to find it. Marissa Lee, my daughter, she's Exhibit S. And if you look at Exhibit S, you'll see my daughter making a formal statement.
Exhibit S. Just fucking understand the alphabet, okay? That's fucking long. That's a lot for a small claims case, folks. Holy shit. Also, did she submit it? I mean, under the penalty of perjury, all these fucking things are popping in mind. This is so boring, but it's also like exactly what landlord-tenant cases are like usually, except the tenant is not usually as prepared. That was very succinct. Citing statutes. I mean, these are a match made in absolute heaven.
Confirming that the before pictures are accurate, that the after pictures are accurate, and I don't know what else I need to prove. I
think
sorry, I've never done this before.
I think you're starting to repeat yourself now a little bit. So, no, I'm familiar, or I think I've got a good grasp of what your defense is, and I've seen the exhibits that support the statements that you're making, and you've also walked me through some of them, which also helps me understand your defense. So yeah, this case is fairly common sort of situation that we see in small claims court with a landlord tenant disagreement about the disposition of a deposit. A lot of times these disagreements boil down to exactly what Arlo said in the beginning, which is this normal wear and tear, or is this something in excess of normal wear and tear? So in many cases, it's difficult to distinguish what is normal wear and tear versus what exceeds that. There's no universal standard to that, and the subjective standard of one person could be significantly different than the subjective standard of another person. But in your case, both of you have presented some pretty good evidence, some pretty easy to follow evidence, and some pretty good photographs that help to see and illustrate the points that you're making about whether we're talking about wear and tear here, or whether we're talking about damage that exceeds wear and tear. So I appreciate you both taking care to do that, because it actually makes it a lot more clear for me to be able to come to a decision here. And what I am going to decide is this. I'm going to decide based on the evidence submitted, the testimony, and the exhibits, that the damage that we see here in the exhibits presented by both parties is in excess of normal wear and tear. And you've got to show by a preponderance of the evidence that your claim, the claim that you're entitled to the return of the full deposit, and you haven't carried that burden, because it has been clearly shown that in a period of 1 year, which not a very long time, that a house that had been very recently brought up to a higher standard had some damage to it that, really only can be explained by being used in excess of ordinary wear and tear. And that's quite obvious. I mean, that GFI cover plate is pulled off, and there's clearly been an attempt to put it back the way it belongs, but it's not. It's clearly misplaced. It's very odd that a light fixture would be dangling by a wire, including the box. The mounting box is on top of it, so it's clearly been pulled down from its mounting position, which is not ordinary wear and tear. And neither is a drawer cover broken completely off. It's in excess of normal wear and tear. Don't know how it happened, but it's not normal wear and tear. So unfortunately, I am not going to make any award here. I'm going to find in favor of the defendant. And there'll be no award of any damages.
Thank you, Judge.
All right. I will write up a judgment that's consistent with that, and you can both have access to that judgment later today when the clerk files it.
Appreciate it.
All right. Thank you.
Was that someone's laundry? Oh, hi, Lauren. I guess we'll stay and figure out what happens with Lauren.
All right, where's the judgment, Chase? Okay, do we know anybody else?
Yeah, so I do have an update for you. We'll start with number 8 on our calendar, Wash versus Departments. They reached a DRC agreement.
Okay, I'll write that down. Thank you.
And then number 2 on our calendar, they had started mediation, but it sounds like the plaintiff in the case wants to request a continuance. So
Okay, is that
yeah.
okay?
And then
Number 4.
and then, yeah, Steve Bryan versus MC Auto.
They're still working.
They attempted mediation, but mediation did not go through. So as you mentioned before, it sounds like that case will be dismissed tonight. Signed off.
Okay, gotcha. Thank you. Okay, let me then next take Helen Immelt versus Omnicenter and Dr. Pricer.
I'm Helen.
Okay, would you have a seat here at the table? And can you tell me if there's a red light on the microphone there?
Yeah.
Okay, good. That way everybody's going to be able to hear you. Okay, and let's get a sound check from you.
Oh,
Make sure
yes.
you're on with
Testing.
us properly
1, 2,
now.
3. Testing, 1, 2, 3.
Are you talking to me?
No,
Okay.
I'm talking to our Zoom participant, Lauren.
Can you hear me now?
Here, that's much better. Okay. So this will be number 37373, and I understand that the plaintiff, Ms. Immelt, you were
37373 is a very excellent number. I don't know how to explain it other than that. That number is excellent. That gives me great pleasure for some reason. 37373. Ooh. I love it. I love it.
contemplating asking the court for a continuance of this trial?
Okay, when I went into the mediation, an office manager appeared, the gal Karen. And I said to the mediator, she's not part of the case. And she said, okay, she could be a witness. I had said to her when I filed the case, I got told at the clerk's office that you have to ask the judge for witnesses or production of documents. One of the things I need for you to see is the doctor took befores and after of the procedure, before the procedure and after the procedure. And I asked for her office staff a year ago and the doctor to send me those photos, either by email or whatever. all they sent me was an email that I gave the court, but I really need for you to see those before and afters, 2 weeks after the procedure. And I need to either dismiss this case, start a whole new case, and have witnesses because of the scar damage in my face and what happened. I didn't know I was allowed to bring another provider here or,
Well, in a medical malpractice case, you're
Yeah,
practically
so,
required to.
the thing is, the standard of care wasn't provided by the doctor. And,
So can I hold,
yeah.
have you stop for a second? Are you asking for a continuance so that you can gather more evidence that you need to present to the court as part of your claim?
Can the court order her
No.
can I make a production of documents
No.
for that?
No, you're in the wrong kind of court for that.
Okay,
The rules that govern what you're talking about there, discovery rules is what that's called.
okay,
That kind of court rule doesn't apply in small claims court. Small claims court is a lot more informal, and there aren't procedures like that in place
okay,
for discovery.
okay,
The parties just kind of, they do it themselves and they present it themselves. It's
Okay.
designed to,
okay,
for more or less straightforward legal disputes between people that don't require a lot of effort to develop the case. If you're interested in using discovery tools like making the other side produce things like documents or answer your questions or things like that, those are civil discovery rules that apply in district court or in superior court. And you are free to dismiss this case and file it in district court or superior court according to your judgment.
and you know what, I think that's what I'll do, Your Honor, because, the standard of care wasn't provided, the medical records I wasn't able to get from her in her office, and the photos, and they're impertinent for this case.
All right, I will go
Yeah,
ahead then.
so I will file a district court and have her reserved and do that. I think
Okay.
I'll, that's what I'm going to do.
Then I will enter an order dismissing the claim without prejudice.
And what is the, I can still file district court here?
You can.
right? Okay.
Yes, it just wouldn't be a small claim.
Right,
There aren't any discovery.
okay. And I'll do my discovery then.
Procedures.
I think I'd rather do that.
Okay, and if you're gonna pursue a medical claim like that, it's probably a good idea to get some legal advice about it so that,
Well,
you know,
my ex-husband was an attorney for 30 years.
all right. Well, I will leave it to you to decide. So, so Omnicenter and Dr. Preiser, the matter is dismissed.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. Thank you so much. Lauren gets away with it for today. I think she's the doctor, but we'll keep an eye out for that medical malpractice suit. You know, when your husband, your ex-husband, did something for 30 years, well, and he's not there with you in court, it really shows how good you are doing. Hi, Sashina. Sorry that tonight is a short one, but that's the way it be. I hope that you guys tune in tomorrow. We have members only. Keep an eye out for it. 11 months, Sashina. That's amazing. Yay! Wait a minute. That's awesome. Yes. Tomorrow, members only. Keep an eye out for it. I don't know what time yet. That'll depend on tonight. I'm just kidding. Donald! Yay! Woo! Wait a minute. Anyways, I hope that you guys have a wonderful rest of your night. I tried to redirect, but nobody was going yet, so go find yourself something to watch. You know, YouTube is a vast place. There's lots of places to be. Yeah, enjoy yourselves. Remember that I love you. Oh, Carla, look at that. Damn. Do-do-do-do-do. Anyways, I have a hot date of sorts. Oh my god, you guys are hilarious. This is how we keep Paisley here. We keep saying how it's almost been a year. You guys are great. I love y'all so much. I better say bye quick. Love ya. I'm proud of you. And I will see you in the next video. Fuck, I gotta find the thing. It's right here. I love you. I'm proud of you. And I'll see you in the next video. Bye.
Ways down and ready to ride.